Thank you for joining our webinar on Justice Adapting Atlantic Canada Courts. Some housekeeping notes. If you experience technical difficulties at any point, please exit the meeting and re-enter using the link provided. Please note that this session is being recorded and LexisNexis will distribute the link in a timely manner. On behalf of LexisNexis and the judges participating on the panel, we hope you are staying safe during these unsettling times. Thank you for doing your part to flatten the curve. The victims, their families, and all the people of Nova Scotia, we are all with you during these trying times. As COVID-19 events continue to unfold, LexisNexis Canada is working to support the legal community. The Practice Advisor Coronavirus Resource page for more information. Today's webinar will now begin. I would like to introduce to you the moderator, Heather Robertson, Manager of the Litigation Practice Areas and Content Lawyer for Intellectual Property and Information Technology of LPA. Heather, over to you.
Thank you, Nana, for that introduction. I'm very pleased to introduce our panelists and distinguished judges from Atlantic Canada. We have with us today the Honorable David Jenkins, Chief Justice of Prince Edward Island, the Honorable Raymond Whalen, Chief Justice of the Supreme Court of Newfoundland and Labrador, the Honorable Tracy DeWare, Chief Justice of the Court of Queen's Bench of New Brunswick, and the Honorable Pamela Williams, Chief Judge, Provincial and Family Court of Nova Scotia. Welcome to you all, and thank you for joining us today. So we're going to jump right in with our roundtable because we have a number of questions for you today, both from LexisNexis and from our some of our attendees who submitted questions ahead of time. So, so let's jump right in. So just the first question is more general. What is your general experience since the start of the COVID-19 crisis for your court level or province? And I thought we would start with Justice Whalen.
Thank you, Heather. I think our experience has been the same as all other courts across Canada. Our court had a full schedule of trials and in 7 different judicial centers throughout the province, including jury trials, of course. And all these were placed on pause. Our registries were closed, our buildings were closed, so it was really not an acceptable state of affairs that we found ourselves in, with wide access to justice restricted in that way. But we faced first the public health state of emergency in our province, and with orders that flowed from that basically instructed the public to stay at home. Schools, businesses, and all regular activity ceased, and we were caught in the middle of that, part of it. I think as well, in our province, the public service gave the executive of the clerk of the executive council gave a directive to the public service that there would only be critical workers that were required to come into work. So we were of course staffed by a provincial public service, so we had to decide what, and we had a pandemic plan in place, so we knew who our critical workers were. But that was a second given to all courts across Canada were facing this. So then in our case, on March 18th, we issued a notice to the profession and the general public that we were postponing matters, civil, criminal, and family, indefinitely. We will be hearing limited matters, some of which were specifically defined in the criminal and family context, and then of course such other urgent and emergency matters that would come to us. And there were some specific examples, as I said, given. All those urgent and applications then were dealt with by teleconference or video conference or a combination of both. I think the experience has been pretty good in that sense. We've been fortunate to have Memorial University as our video conference platform provider for more than 7 or 8 years now. So we were able to extend that video conferencing, not at the beginning, but during the course of the process, so that we can actually now go out to anybody's office or home if necessary to hear them at them. So our experience has been good, and we did ramp up in terms that we can also now have and have used mobile recording capability to run 2 courts virtually if we had to. In most cases, the judges have used the courtroom as the base, and everybody else appearing by way of video conference. So the experience has been pretty good, and I have to say that we've been, without question, have had very cooperative and supportive legal community. And the bar realizes that this is uncharted ground by any of us. So our experience that way is pretty good. But now I think, like everyone else, anxious to get back to normal, whatever that is, in whatever normal is for the general population, and whatever our new normal is for the next period of time as well.
Right.
That's about it.
Thank you very much. Justice Jenkins, I'm wondering if you have any comments on that.
Sure. Thank you, Heather. And also thank you to LexisNexis for arranging this guinea pig webinar that we're on here today. And I'm glad to participate with my colleagues from across Atlantic Canada and to reach out to the legal community in this way. We're all in this together, and over the past period since March 13th, we've been sharing a lot of notes with each other for best practices. And it's also good for consistency for the public and for the bar to see that we're on the same page. I do want to take a couple of minutes, if I may, just to share the PEI experience or story. I did a post on the National Self-Represented Litigants Revolution blog on this, so it can be found there. But we've had, I think, really good success in the circumstances, just like Chief Justice Whalen was talking about. But on March the 13th, we all arrived at work at the same time and said, we've got a crisis on our hands here, and we don't really know how to deal with this. And we formed ourselves into a meeting, and we ended out, there was about 8 of us involved, court services from government, the court on the ground staff, including the Prothonotary, represented the 3 Chief Justices. And I think very smartly, we included the secretary, or the executive director of the Law Society. So we formed into a fairly nimble group that were able to make decisions on the spot. And we had to reach out a live line to the Minister of Justice office and to the Chief Health Emergency, forget the proper name, office. And so with that, we were able to be collaborative, and we were able to be quick and effective in our decision making. And that, I think, really worked well. The big thing at the start was getting the courts closed down, recognizing the principle that courts never totally close, and there needs to also always be access to justice for urgent emergency matters. But getting things safe for the public and safe for the court staff, and then trying to develop a respectful balance between the health, respecting the health emergency requirements, and at the same time providing those minimal services. So a little later I can tell you about some details, but I just, I was really pleased to be part of this group on the island, and I think that at first we went every day, and then we went every second day, and then we went twice a week, and now in week 7 we're down to once a week, so that's a good thing. So thank you very much for the opportunity.
Yeah, thank you. Do any of our other justices have any comments for the first question?
Heather, I'd like to make a comment. In Nova Scotia, in the provincial court, it's a very busy place. Often we see hundreds of persons walk through our doors each day, and so as others experienced the urgency in trying to reduce the numbers that were coming through our doors. And so the urgent matters that we had to really focus on were people who ended up being arrested and in police custody, because liberty issues need to be addressed quickly. And so we were able to, with the use of technology, both video and audio, start to have bail hearings, both consent hearings and contested hearings, and do some bail reviews, because one of the obvious concerns was the large number of people in correctional facilities and the concern of the spread of COVID-19. And so as in the PI experience, we have been very collaborative in terms of assessing those people in custody, and Crown and Defense determining those who may be able to be released. So it's been certainly a very collaborative and cooperative venture throughout.
Great. Justice DeWare, any comments?
Sure. Perhaps I could just echo really the experience discussed by the judges from the other provinces, exactly what's happened in New Brunswick. And I guess as challenging as it was to try to quickly essentially shut down a justice system while still maintaining access to justice for those essential matters was, quite a challenge for all of us. Now we have the challenge of opening it up again in this new normal. So our experience certainly on the shutdown and trying to get things organized is exactly the same. And now we've sort of switched gears to try to get things open again, which is proving to be equally as challenging.
Right. Thank you. Okay, so we're going to move on to our about virtual representation, and whether you already had measures in place for virtual representation, or whether you had projects that were in progress to offer this kind of technology for hearings. So I'll turn that one over to Justice Williams.
Okay, thank you, Heather. So we've had video conferencing capability in most of our courtrooms around the province, probably for the last 4 or 5 years. We have one of our Supreme Court courtrooms that is completely outfitted virtually for a full hearing. We'd like to see that rolled out in other courtrooms across the province as well. So having the assistance of video conferencing has meant that we've been able to do bail hearings with persons in custody, connecting by video as between the courts and the correctional facilities, and have had Crown and Defense appear by telephone for that purpose. And if there are witnesses, then those witnesses have been in the vulnerable persons room also at the courthouse. So, we haven't had a platform that has allowed us to have fully virtual hearings with parties outside of the government system, but we have been able at least to deal quite effectively with people in custody and to determine liberty issues.
Great, thank you. Do any of our other justices want to comment on the other jurisdictions?
Oh, sure. I was waiting to see who was going to go first. I didn't want to be
jump right
first every time. I think our experience is fairly similar, and there's variation for different kinds of courts too. But we've had the video feed from the jail for some time, and we also have the capacity to hear an expert witness from afar that way. And telephone technology, of course, is old school now, and conference calling. But I think that what this has done is that we've had the pieces, but I don't think we've ever put them all together. Mm-hmm. And that's what we're going through right now. And we've had the capability, but maybe didn't even know that we had the capability for video technology. And so our default has been to have a hearing in person at the appeal level anyway. And this has really been a catalyst to force us to get there in a hurry to find out how we can utilize this technology for remote hearings. So.
Right. Okay. Thank you. Anything further from Justice DeWare or Justice Whalen?
Maybe I would just add that while we've been doing the video conferencing for the bail reviews, bail hearings, things of that nature, and I think everyone's scratching their head and almost asking ourselves, well, why didn't we do this before? You know, this seems to work quite well. And the only challenge we have at the moment is, of course, our court is using those technologies now, as is the provincial court, as is the Court of Appeal. So all of a sudden, equipment that was hardly ever used has been dusted off, and everybody wants it. So that's
Right.
the challenge, is trying to have the equipment available to the particular judge and to the particular court when they need it. So I think the province is going as quickly as they can to get us more equipment, and to Justice Williams' point, hopefully to roll out this stuff as a matter of course in all courtrooms would be the ideal, but that takes some time and of course some resources as well.
Right. Justice Whalen?
Okay, a little bit of a different experience. I think that in our province, certainly in the trial courts, video and audio capability has been used for quite a number of years, and used relatively any given day. There will be quite a number of courtrooms throughout our province that will have a hearing taking place in part or in whole by audio or video conference of some sort. Not trials, but those that lend themselves to appearances and so on. Again, like bail applications. So we did have, I think, quite a bit of use of the equipment. It wasn't always used, and it certainly wasn't going to, it's going to be used for different things going further. What we were able to do because of COVID-19 and the pressure to try and you know, expand what we had, working with Memorial University, we now do have the Zoom capability, if you would, to our, and I mentioned this, I think yesterday to a couple of the chiefs, and for a while we've had it now in the last couple of weeks, and it's working its way through all three levels of court, whereby they will provide capability of hearing matters where people are in their offices or in their homes, and the judge themselves. We've had urgent and emergency applications dealt with where the judge was in a home office or not in the courtroom for sure. And
Right.
we've been using that courtroom as the recording base. And as well, we've now had put to use on just one occasion, a actual portable recording capability. So everybody was virtual. Certainly logistically, it's difficult. And it's not going to lend itself to a large number of matters. But going forward, obviously, this will be something that we will try to utilize even more. So it's more convenient to the practicing bar and the individuals.
Yeah. Okay, great. Thank you. The next question is about court rules and whether you had to modify, adjust, or apply differently some of the court rules, and if so, if you have any examples, and also how you made that information available to the public and legal community. So I'll have Justice DeWare start us on this one.
Sure, thanks, Heather. Probably the biggest change we made was to allow for electronic filing, and that's something that everyone's been saying for certainly 20 years, oh, we should do that, and it always seemed to be insurmountable, and then it was a decision made in about 5 minutes once COVID-19 hit. So it's funny how things change so quickly. So that certainly facilitated the ability of people to get documents into the court and cut down on the traffic into the court. As well, it became apparent very quickly that we were going to face difficulties with people unable to get affidavits sworn, unable to get consent orders sworn, people out of the province, people in quarantine, whatever the scenario might be. So we introduced flexibility around that. We allowed unsigned, unsworn affidavits to be filed at the outset, to be confirmed at a later date. Also, we just as a matter of course started as time went on to hear whatever motion we could over the telephone, just to try to keep things moving, and that went very well. We also started doing virtual settlement conferences, and the impetus for that was thinking, well, if we can settle some of these cases, that will help us when we pull out of this to alleviate some of the backlog. And those have actually worked out really well. We've seemed to have pretty good buy-in from the bar. The judges have been willing to give them a whirl. We've done them on Skype, we've done them on Zoom, we've done them on some just via telephone because either parties or lawyers, whatever the situation was, didn't have access to sort of a virtual experience. And that's been helpful. So I would think, I think those are the biggest changes we've made. And in terms of communicating that, we've had an NB Corp's website for quite a while. I think most provinces do, which I don't think anyone ever looked at before. And now it's taken on a whole new life because that's where all the directives have gone. And I think we've really realized how unutilized that means of communication was, that we really need to keep that up to date. So that's been a valuable tool, along with, of course, disseminating information through the Law Society to Council and having the information available at the clerk's office to provide to parties when they call in. So I would say those were sort of the biggest changes we made in New Brunswick.
Excellent, thank you. Justice Williams, did you want to add further comments?
Sure, we've done a lot of the same as has New Brunswick. There's a lot more e-filing, whether it's informations or applications. There's been a lot of collaboration and cooperation as amongst the bench. So every Tuesday now, there's a bench meeting virtually by telephone. We discuss issues that arise through some of the virtual directives that have gone out and have sought input and improved upon them. And so anything from, we're now doing e-warrants, we're doing ex parte e-applications to unseal search warrant informations, applications to vary release orders are all done by electronically in PDF fillable forms. And so it's really quite amazing, as Justice Dwyer said, you know, in the past it's been insurmountable, either because the technology isn't available or the resources are not there to pursue these projects. And it just amazes me how, when you're in a crisis, all of a sudden, when you need to adapt, you do. And we've been able to find the means with which to do virtually most things other than the trials themselves.
Right, yeah, it is amazing. Justice Jenkins, any further comments?
Just to mention that in the question you asked about court rules, we kind of put the rule book aside and looked after the essentials by using directions and communications with the legal community, recognizing that we'll have to go back to the Rules Committee in the longer run to see what should become rules and what was just temporary for this COVID situation. The key person in this situation is our pathonetary. It's hard to spell, but it's certainly a handy thing to have, because Krista McKay QC, she's on the ground and she handles all these in conjunction with the executive director of the Law Society and the court service manager. And so it's been working really well. And, you know, within a week of March 13th, we had developed protocols for e-filing documents and e-payment of court fees. And we use the same kind of reach out that the other jurisdictions are talking about, and that we can immediately reach out to the Law Society and inform them of what we're up to, and what they can let us know what their needs are. And as Tracy was saying, Chief Justice Dwyer was saying, that the website, who knew it would become a popular read, but it's full of all sorts of exciting material now. So that's what we're doing.
Oh, good. Okay, Justice Whalen, any comments on your jurisdiction?
And we certainly did modify the rules, but took an approach similar to PEI, just very flexible on what the rules were. We're going to immediately put not the rules aside, but certainly we were going to be inventive in whatever way we could get urgent applications before the court, or anything that we could do without the necessity of service, and avoided the rules to make the work flow. I don't want to say we put them aside, but we did bend the rules quite a bit in order to allow, for example, just as an example, people who had an urgent probate that had to be done, then the normal rule would be that the will had to be with the court. Well, we were prepared to accept an undertaking from the lawyer that they had the will in their possession and would file it when court resumes normal operations. Ongoing, as the ground was changing underneath us, we were making those sorts of decisions. So I think we kind of bent the rules, and we will continue to do that to try to obviously have access to justice.
Right. Yeah. So it sounds like for most of you, there have been some sort of amended rules or changes to rules, or as you said, Justice Whalen, bending of the rules. So the next question is, do you think these changes in the court rules could stay in place for the future after the courts come back to normal? So I will hand that one over to Justice Jenkins to start us off.
Okay, thanks, Heather. I don't know what normal is going to be in the future. I don't think anybody really does. So the way I kind of looked at that question was to look at where we were when the crisis hit, what we've done since, and what might the new way look like. And where we were, we've discussed already that I think in all of the jurisdictions, we had a lot of the digital pieces in place, but they aren't necessarily all linked together, and they weren't being utilized as much as could be the case. What we were able to do, it's impressive the amount of workarounds that have been developed by everybody pitching in. As we talked about, within a week, we had documents, filing, fees, payment, alternate methods. One thing that is avoided now is lineups or waiting times to put documents into the registry, because you drop them off at the front of the courthouse when they're left there, and they're called when they're filed. Probably the biggest thing that we're working on right now to get it right is to be able to do the hearings by video when they're needed. And our IT people have been working with us, and there's a few different technologies that we've been looking at: Resolve Technologies, WebEx, Court Call, and I think that our IT person is even working with Arbitration Place right now, looking at those kinds of things. So hopefully that will take us, some of this will get us through as we move out of the urgent and essential matters into more matters that need to be heard. What it will look like in the future, I don't know any more than anybody else, but I think that the door was slammed shut by COVID just overnight. And so it's forced us to bring some good innovations into place. I think some of them will be here to stay in some form or another, especially the use of technology. I just want to share with the group that this was a total coincidence. Literally almost the last act that I did before March 13th was that I'd ordered this book, and it came in on March the 3rd is when it came in, and I started to read it. And it's about online courts by Richard Susskind. And he talks about it, and he says that we're really doing online courts to some extent now, even if the litigants aren't participating in them that much. The research that we do with LexisNexis is online. The filing of factas in courts of appeal is online. So I just see what the question is, what the future will look like. There'll be, I think, a lot more technology, and I think especially at the appellate level, I think there'll be substantially more remote appearances.
Right. Thank you.
I defer to the others on the trial matters.
Okay. Justice Williams, we'll go to you next.
Sure. So we do have a virtual courtroom project in our Supreme Court, and I think that experience will help inform how we can roll that out to the other levels of court as well. My view is that the use of technology, I think, it increases access to justice and creates efficiencies within the system that we should be continuing to pursue after COVID-19. We've got lots of best practices and lessons learned to improve on processes. And so I'm hoping to see lawyers and judges, when they're putting their mind to certain procedures, to think, okay, is this something that could be done remotely or virtually? Is this something that requires an in-person hearing? And this experience hopefully will leave members of the bench and the bar with asking themselves those questions as we go forward.
Thank you. Justice Whalen?
I don't think that there's any rule changes that immediately come to my mind that we will follow through on, because we're still going through it, and there's a lot of things that I'm sure that we will look back on and say that was a good idea, we should do that, but nothing really stands out to me, other than that all our rules need to be overhauled for sure, and we're trying to work through that. But as for the COVID-19 and what we've done, the changes in our court rules specifically, I don't think that there are any specific ones that stand out that we will implement. If we're talking about more changes more generally, about what changes have happened in the court more generally, and I know my colleagues talked about technology and where that may lead, and I always find this a kind of a interesting criticism of courts as an institution, because there's really two facets to the technology question, and they get commingled when people are arguing about it. One is the virtual appearances and the ability of hearings and conducting court proceedings using audio or some sort of remote technology, digital now, but nonetheless video platforms of some sort. And can courts do that? Should courts do that? We're doing that in part and in whole. And I think that's going to be improved. That will certainly be improved and expanded. The second part of the technology question is completely different, and that talks about the idea of being a electronic court, where we can accept filings and retrieval and archival of documents and so on. And as superior courts or courts of record, the systems that you would need to create a truly electronic court would cost in the many tens of millions of dollars. We've already looked at it in terms of trying to get robust case management. Electronic case management systems are always, in the multiples of 5 millions for sure. I think the only court really has had any success on the second aspect of technology has been BC, and they have done very, very well. They've pumped a lot of money into it, and they could be considered an electronic court, and they accept filings in a lot of different matters, and they have the archival capabilities in their systems.
Right.
So
it's a cost factor as well. Interesting. So Justice DeWare, did you want to comment on that?
I guess the only thing I would add, similar to what Justice Whalen was saying, certainly I think following this, we'd like to see our rules amended so that we can provide under the rules for the filing of electronic documents. But it's a two-step process. We can make those changes so people can send their documents, but it would be fantastic if then we can take the next step to really become electronic in terms of the management of that information in that database. But that's a huge project, and as Justice Whalen pointed out, very expensive, but hopefully someday we'll get there. And I guess the only other, I think the big takeaway is going to be, all of a sudden we had to get everybody out of the courthouse, but there were certain matters that had to proceed, and we found a way to do that. And I think going forward now, when we have a situation that there's a trial or there's a motion, there's a matter, and someone's in Fort McMurray and can't get back to New Brunswick, or there's an expert in the States who can't travel, or there's someone ill that can't, instead of thinking, well, we have to adjourn the matter, the focus is going to be, okay, well, that witness can't testify in person, or that party can't be here. How are we going to accommodate them? So I think that's going to be a positive change, and I think for the bar, the bar's been fantastic. They've been very collaborative, as has the judiciary. I think it's sort of been a shift in everyone's mindset now. Instead of, well, no, we can't do that, now we've kind of gone to, how can we do that? And I think it's very positive.
Good, great. So the next question is about how you manage emergency hearings, and specifically, what are the criteria for emergencies in your court level? So I'll turn that one over to Justice Whalen first.
Okay, the approach that we've taken on urgent and emergency application is a triage approach. It's pretty consistent across Canada. Again, maybe not surprisingly, the Chief Justices are always in contact with the other Chief Justices of their courts, their level of courts throughout the country. So we keep very abreast of what's going on. But as it happened, I think without planning, all courts pretty much approached these applications in a triage basis. There was no rules around what triage meant, so the party seeking the application for a hearing or something to be dealt with on an urgent basis in Newfoundland and Labrador presented the application by email or fax, and then and I should note very quickly that the application didn't have to follow and didn't follow in a lot of cases any formality to it by having to be look like, feel like, speak like an application. It often was by way of email explanation or covering letter that the facts as to why a particular issue was considered to be urgent, and that was presented to the court. Then the triage judge, I had a rota of triage judges on duty, would exercise then, having received that information, with obviously a copy of the application was normally attached in some fashion, received by email in most cases. We would make that, photocopy that, provide that to the judge, and have the judge deal with it as a triage, on a triage basis, weighing the facts that were presented that were best available. And again, we had to go on the presumption that someone was looking for an urgent matter to be dealt with by the court, that they were going to present to us in the first instance as a whole and a thorough set of facts and as to why this was urgent to be heard. And we would again obviously weigh that evidence that was presented as judges do regularly in exercising their discretion on a whole lot of applications. In this case, the exercise of the discretion was in the context of COVID-19, in the context of the public health state of emergency and the chief medical officer's orders as to which effectively had closed down normal day-to-day activities in our province. So it's in that context. And also there were, of course, a certain set directives on social distancing. Now that doesn't affect the application, but affects the workforce that comes into the building that you got to have to support the hearing of certain matters. So there's a workplace people resources needed to deal with the application as well, which just again is the context in which is this urgent? Are we going to put people in motion to come in to hear this in contravention of the chief medical officer's orders to effectively stay at home unless it's critical? So it's in that context that the judge exercised her or his discretion to decide whether the application would go forward. In a family context, it was more difficult, probably because there were many more self-represented litigants. And while the judges write, in our case, a one-page or two-page endorsement as to why they're not accepting it, in the family context, we did actually issue a notice to the profession very recently, though, defining what urgent meant. There had been law coming out of Ontario and BC on it, but we felt with the number of inquiries we had to actually strike a definition in the family context. We did do that. Not an exhaustive definition, but we published what would be considered.
Okay, great. Justice Jenkins, any comments on what the criteria for emergencies would be?
Well, just to add on to what Chief Justice Whalen is mentioning there, we decided not to try to make lists of what is urgent because it needs to go on we thought it needed to be addressed on a principal basis, and we're just learning as we go along. And urgency is in the eye of the beholder to some extent, and it also depends on time. What is not urgent today may be urgent in weeks down the road. So the key to the whole thing is an objective evaluation of urgency by, as Ray mentioned, a triage judge to decide that, and that judge needs to have some kind of a short submission from legal counsel, self-represented, as to why the matter is urgent. And I know from working with the other chiefs in the trial courts that they're really finding that you have to evaluate it as it goes along, because there's only so much capacity in the face of the emergency. And then with the gradual opening up that the provinces are doing, then we have to move kind of in tandem with that. Chief Justice Clements calls it finding the sweet spot. And I think that's, but we do it by trying to stay away from lists, and it's a little harder to follow, but our prothonotary explains it to people as we go along.
Great. Justice DeWare?
Maybe the only thing I would add is initially when this started, we were very restrictive, or we interpreted urgent as, well, very restrictively. And the example I had given to the judges, well, urgent would be that a child needs end of life or life-saving care and a parent's not consenting. That would be what would be considered urgent. And that would be in the beginning. And I think at the beginning too, we really didn't know sort of, one, how long this was going to last, what our staff was going to look like in terms of those critical services, what we're going to be capable of doing. As time has gone on, like Justice Jenkins and Whalen have said, sort of things change, and we have become a lot more flexible. And as time's gone on as well, you know, a child who hasn't seen a parent for 2 weeks is perhaps not the end of the world, but when you have a 2 or 3 year old and now it's been 6, 7 weeks, it starts to be a different situation. So what we're hearing now would be much more, there'd be quite a few more cases that have gone through in the last week and will throughout the month of May than certainly did during the first couple weeks of the situation.
Right. Justice Williams, any further comments?
Just from the perspective of the provincial court, liberty issues are always seen as being urgent, and peace bonds, because it is difficult to determine on the face of a document which matters are volatile, which matters can wait. And so triaging those matters and then trying to determine whether or not a telephone conference can accommodate 3 principles: due process, full disclosure, and trial fairness. Taking into consideration, are there witnesses, are there exhibits, are there issues of identification? And so we have developed a process and have identified 3 presiding justices of the peace to triage all of these matters and hear those that are capable of being heard over the telephone. So those were some of the types of cases that we saw as urgent matters.
Right, thank you. So we have about 15 minutes left, so we're gonna move on to some of our questions that we've received from participants. So the first one I will direct to Justice DeWare because it's a New Brunswick question. And the question is, what innovative measures could be implemented to deal with the expected significant backlog of child protection cases as well as other family court matters?
Okay, thank you. Well, there's 2 parts to that question. One, we do, even before COVID-19, in some of our jurisdictions, we do have a significant backlog in family division, and that's sort of a systemic problem that exists. I'd love to blame it on COVID-19, but it was there before. I can't, and that's going to still need to be dealt with. In terms of all the adjournments from March 15th until May 29th, where our go back date right now is June 1st. But for that glut of cases that were adjourned, what we've done is created a separate docket for the entire province where all of the adjourned matters have been put, including, of course, all the child protection and family matters. And that's called the recovery docket. The important thing with that is for everyone else, if you've been waiting for the last 9 months for your court date and it's scheduled for June 15th or July 1st or August 17th, those will go as scheduled. Those will not be changed. It's sort of like the Air Canada flight that gets canceled. You can't bump the next people on the flight. You've got to wait till we can fit you in. But how we're going to do that is we've had a significant amount of time saved through settlements, amazingly, through settlement conferences. That's all gone to the recovery docket. Given the current situation within the country and really the world, all of the conferences, all of the education that typically the judges would be attending, of course, is not taking place. All of that time's gone into the recovery docket. And the judges typically take a significant portion of their vacation during the summer months, which is helpful because there's not a lot scheduled in the buildings during the summer. The judges have all donated time from their vacations this summer. They're just going to work instead of taking that time. time. And because nothing was scheduled in the court building, we're able to use that time effectively. We have 600 days banked now of justice or judges' time to address the recovery docket. But of course, we have to be cognizant of the fact that we need to make sure that the buildings can handle so much capacity. What will the staffing be like? So we're hoping to be able to do relatively maximum capacity during the summer. And if we can, we're confident we can clear up that backlog by the end of 2020 for sure.
Wow, that's great. Thank you. Our next question is from Newfoundland. So the question is, I have 4 criminal jury trials, 3 already scheduled and 1 to be rescheduled over the next 15 months, in addition to civil matters not yet litigated. So how do you see jury trials taking place in an era of no vaccine? Will jurors have a legitimate reason to be excused? And will trial participants and witnesses, judges have a right to request adjournments? So I'll turn this one over to Justice Whalen.
Well, it's a multifaceted question.
It is.
Let's look at the big picture. How are jury trials going to fare, or how are they going to take place in an era of no vaccine? And when is that going to happen? Same question being asked every Superior Court trial court across the country, and nobody has the answer. In our case, what we've done is I've written to the chief medical officer and asked her for her advice on that, exactly when that she would anticipate we could have such a gathering or gatherings, and I'm waiting to see what she says on that. I haven't had a reply. The second is we've checked with health and safety of our province. We've got to look at each one of the buildings and evaluate where could we have the most social distancing for trials and in particular for jury trials. So again, we're waiting for their report. I don't think that we can really see that jury trial is going to happen anytime soon. It's not until in our province up until June, at least as of right now, we're limited to 10 people maximum in any gathering. And that looks like it's going to be in place for at least 28 days. So we're going to be well into June before we're talking about increasing the numbers of people that could gather, even if we could possibly conceive a jury trial taking place in June. I don't want to make any kind of announcement, say we're not going to be doing jury trials until such and such. I know because I don't have that date, and that plan hasn't fallen in place yet. But certainly it's on the, it's being worked on every single day. It's being looked at. I think that one of my colleagues may correct me, but I think Ontario has announced that they're not having any jury trials until at least September. I find it difficult to think that we're going to have jury trials available to go in July or August in Newfoundland, but I don't know yet. So to answer the big question, justice, which the author of your question put in, justice delayed is justice denied, but that's been the impact of COVID-19. Justice is being delayed, and jury trials will be delayed most of all. Again, obviously, we're looking at kind of what facilities are available. It's somewhere in the province that could house, like a convention center that could house the actual picking and of a jury, the impaneling of a jury. But again, that's we certainly haven't laid out a plan on that. Some have suggested that jury trials may not be feasible until after there's a vaccine. So that's the other bookend. I guess to individual who asked the question, all I can say, even with a busy schedule, that you'll have to stay tuned on that issue. Right. The second part of it was, will jurors have a legitimate reason to be excused? I think it'll be one of those reasons that people will put forward if they are picked and asked to serve. And it's then got to be decided whether it's a valid enough reason at that point in time, and where are we with the pandemic when that jury trial is going ahead. If it was now, I think people would raise it, and I think that the pretty legitimate excuse. Will it be that in 5 months from now, or 6 months from now, or 3 months from now? I don't know. So I think it will certainly be a legitimate reason to put forward for if someone felt that. I'm not sure whether or not it would excuse them. I wouldn't want to prejudge that. The other part of that question was, will trial participants have a right to request adjournments? Lawyers, witnesses, and so on. Not so confident the witnesses will have a right to an adjournment per se, but they're on one side of somebody's case, so that the issue would come to the court. But I think an application to modify a trial date, that's not unusual. That's happening every day in our court. So if someone wanted to modify a date that is set because they would be concerned around COVID-19, they can take that application in the context of the timing of this being heard. It would have to be decided by that judge at that time.
Great.
So no answer in advance on that one.
Thank you. We have an interesting question from one of our attendees, so that will probably be our last question. And it's about media representatives. So how have the courts allowed media representatives to cover proceedings during the pandemic? So maybe Justice Jenkins, I'll start you off with that one.
I thank the person for that question. I think it's an excellent question in the face of this. We have the open courts principle in Canada, and all courts respect that. And justice must be seen to be done. And so we have to find ways to have access to the public generally, and to the media in particular. Some courts are taking the approach that the media will, in the short haul at least, that the media will substitute for the public in terms of serving the public interest and keeping the vigilance and the watchful eye on courts. We want them to be open and public. We're just in the process of issuing our direction for video hearings right now, and some appellate courts are sort of confining it to media, and some are saying the presumptive approach that public access is there applies. The logistical considerations are the broadband and the computer and the platform. The practical consideration is that you can't rebroadcast a court proceeding. You can accredited media can take notes. So how do you assure that that's going to be respected? And so we're looking at various ways through the use of undertakings or informing the public and media that that's the rules. But I think that you'll see that, and I realize I respect that it's different for trial courts, but I know that our trial courts, in the cases that have been done on an urgent basis in the last month, have been using telephone technology to give media access to all the hearings.
Interesting. Justice Williams?
So in Nova Scotia, we have been very fortunate to have had a communications director with the judiciary. And so she is in constant contact with media, and we've developed the ability for media to call in on any hearings they wish to be present virtually on. The challenge is media in these times of COVID-19 don't always know what emergency matters or what matters in particular are being heard by the courts. And so again, our communications director is assisting there with making dockets available to media. We have on occasion done webcasts on matters that are perceived by the public to be high profile. And so although we don't have the capability of webcasting all courts at all levels in Nova Scotia, there may be select cases that are deemed to be of particular importance to the public that could be webcast as well.
Great. Justice DeWare.
Well, that's a really interesting question. Just before the webinar today, I actually had a conference call with the major news outlets in New Brunswick to talk about how we're going to handle their presence in the courtroom when we start to do in-person matters in June. One of the problems we feel we may have is that we're going to be limited to the number of people who can be in any given courtroom because of the social distancing requirements.
Right.
So we're having numbers of people fixed per courtroom, and they won't be able to exceed that. In matters where there could be several lawyers or several witnesses or parties could want support people with them, we don't just sort of want to have 1 or 2 spots always available for the media, because they, for 95% of the matters in the Court of Queen's Bench, they're really not interested. So that was part of the conversation we had with them today is, look, folks, we want to make sure you're there. We want to make sure you can attend any case that's of interest to you, but can you let us know when you want to come so that we're not reserving spots for people who aren't going to be there. And I think how we're going to try to deal with that is providing lists of, or providing dockets to the media 1 week ahead of time, and just asking them to flag any matter they'd like to attend, and we'll make sure that there's availability for them. And if it's a matter that's a particularly high interest, or there's more people that are interested than we can accommodate, we'll accommodate them via telephone or some other means, which is, they've been present in the court up until now during the more strict measures. And we've also had them available on the phone when we've issued decisions and done things like that on the telephone since it was shut down in March.
Wow, interesting. Justice Whalen, any comments?
We have a standard media protocol that was worked out with the media. There's a media list that we have. All our urgent matters that get to the hearing stage are posted on our website, and the media know that if they want to join in any one particular of those, they call in. They have access to, again, the both platforms that we use, Court Call and teleconferencing. So it will be specified as to which one to use, and they call in. So far, on any of the emergency matters, I don't think I've had the media actually be present on any, but it could have been, and I not know about. But certainly they have access.
Okay.
That will continue to be the case until we get past video conferencing.
Right. Okay. Great. Okay, so I think that wraps it up for today. So I just wanted to say thank you to all of our participants joining us today. The link to the webinar will be available soon for the recording. It will be sent to all the participants that have registered. Don't forget to register for our next webinar. It'll be held on Thursday, May 7th at 2 o'clock Atlantic time. And that one is with the Executive Director or President of the Law Society for each of the Atlantic Canada provinces. A big thank you to our distinguished panel of justices today for your time and important guidance during this event.
Thank you.
On behalf
Pleasure.
of LexisNexis Canada and myself, stay safe. Thank you.
Thank you.
Thank you.
Take
Bye-bye.
care.
Thank you.